So I am pleased to introduce PHMSA's relatively new Chief Counsel, Teresa Gonsalves, and I was the one that chose the title for this. She didn't, so I tried to choose a title that would bring people back in the room to find out whether they needed to be worried about PHMSA's new enforcement efforts. But Teresa will tell you what it really means. So help me welcome Teresa Gonsalves. Push the magic button here. Whoops. We lost you. Let's try to resync it. It wasn't me this time.
This is the slide presentation, right?
Technology and computers saves us so much time. Have you noticed how we've gone paperless? I remember everybody is saying when we get computers, we'd go to a paperless society. I'm still blaming Craig with Marathon's video that he put in this computer. There we go. We're back. Okay, again, Teresa Gonsalves.
Well, good morning, everyone. So since this is a food for thought presentation, I thought it might be appropriate to start with a philosophical quote, which is applicable in some scenarios and not others. So it was Nietzsche who once said that insanity is rare in individuals, but in parties, groups, and nations, it is the rule. So if that's the rule, then I think this is the exception. We seem to be the exception because we're all like-minded. Maybe we have different motivations for being like-minded. Maybe we're motivated by environmental concerns. Maybe we experienced a personal tragedy. Maybe we're motivated by science. Maybe we have concerns about liability. But for one reason or another, we all care about pipeline safety. And that's the reason why I'm so pleased to be here. I'm also pleased to be here because the last time I was in New Orleans, I was 16 years old. I am now a multiple of that age. I'm not going to tell you the multiple. But it's nice to be here as well. So I do want to talk, Carl, about the assigned title for this presentation. Should you be worried? PHMSA's new enforcement efforts. I learned from a young age that being worried may not be so productive. It may not be so constructive. So I'm hereby changing the title of this conversation to, should you be concerned? Concerned just implies that you recognize an issue and you want to be constructive. Being concerned means you're being constructive about confronting it. So let's talk about PHMSA's enforcement efforts and what they're all about, our new enforcement efforts. Obviously, PHMSA wants to encourage and incentivize proactive measures to promote safety and to prevent accidents. And we want to deter activities that can endanger public safety and the environment. Our goal, as well as many of your goals, is to keep the product in the pipeline. And as has already been expressed by previous speakers from PHMSA, we have an amazing group of people that are focused on doing just that. And I should add, in my little shout out to the Office of Chief Counsel at PHMSA, that we have an amazing group of dedicated and gifted pipeline attorneys who stand ready to enforce the pipeline regulations and to do what is necessary from a legal perspective to further PHMSA's safety mission. So here's an overview of a few things that we'll be talking about today. First, we're going to be talking about PHMSA's new emergency order authority. Secondly, we're going to be talking about higher civil penalties. Thirdly, we're going to be talking about PHMSA's efforts to provide greater transparency in its penalty determinations. And fourthly, we're going to talk a little bit about PHMSA's rigorous case tracking and management of enforcement cases. Let's turn first to PHMSA's new emergency order authority, which we also call its new EO authority. So the 2016 PIPES Act granted PHMSA new emergency order authority. This emergency authority, order authority was largely based on what our hazmat program currently has. The great thing about an emergency order is that it can be made applicable to several or all operators within an industry. On October 14th, PHMSA's interim final rule, or IFR, implementing the authority was published in the Federal Register, so this is a very new development. And this IFR establishes interim regulations to implement this new authority. This is really a big deal for PHMSA's safety mission. It's something that our Administrator Dominguez talked about in her confirmation hearings. That's something that she wanted, and it's something that we recently were granted. Prior to this grant of new authority, PHMSA's existing authorities permitted it to issue a CAO, a corrective action order, to a single operator. Safety advisories, which could be issued industry-wide and serve to guide and advise the industry, they weren't necessarily as effective where an imminent hazard exists. And we're going to be talking about imminent hazard in just a moment. And an EO could be more effective, could be a more effective tool in that scenario. So what is an emergency order? It's a flexible tool. It's an enforcement tool that can address time-sensitive safety conditions affecting multiple pipeline owners or operators, facilities, or systems or industry-wide concerns. It's a written order that can only be issued in limited circumstances, some of which we'll be talking about in just a moment, and it imposes restrictions, prohibitions, or safety measures on affected entities. This order can be issued without notice. And let's look now at the definition of imminent hazard, which I said that we'd be talking about. So under what conditions may it be issued? An imminent hazard must exist, and here's the definition from both the statute and the regulations. So essentially, you have to have a substantial likelihood that death, serious injuries, severe personal injury, or a substantial endangerment of, of health, property, or the environment may occur before the reasonably foreseeable completion date of a formal administrative hearing. So it is the administrator of PHMSA that makes the determination of whether or not an imminent hazard exists. Prior to the issuance, under the statute, PHMSA has to consider a number of factors. And these factors include the impact that an EO will have on public health and safety, national security, and the ability of pipeline operators to maintain continuity of service to customers. And of course, there's an opportunity for an entity aggrieved by an EO to file a petition for review. So this is a new authority granted to PHMSA. So these examples that I'm about to provide of circumstances under which an EO may be warranted are certainly not it's not an exhaustive list. There may be other circumstances, and the circumstances will evolve as the authority is used. But one example of a possible place where an EO could be used is where a natural disaster affects multiple pipelines in a specific geographic region, where there's a serious flaw that poses an imminent hazard, and that hazard has been discovered in pipe, equipment manufacturing, or supplier materials. And a third possible example is where an accident reveals a specific industry practice that poses an imminent hazard. So that's emergency orders. Are you concerned? Let's turn now to the second topic, higher civil penalties. So by way of background, the Pipeline Safety Act of 2001 increased maximum penalties, and they're set forth on this portion of the slide. And then recently, within the last couple months, PHMSA increased these maximums under a civil penalty inflation rule. So those are the maximums that we're presently dealing with. And those new maximums apply to violations that occur after August of 2016. But recently, we announced even higher civil penalties. So just 4 days ago, in a Federal Register notice, PHMSA announced its most recent changes to its risk-based penalty structure, and these include across-the-board increases in civil penalties, enhanced civil penalties for certain violations. So the three types of violations where we are applying enhanced civil penalties are violations that are causal to incidents, violations that increase the severity of incidents, including those involving smaller hazardous liquid spills or methane releases. Now, Holly Puron yesterday from the EDF mentioned that this specific provision on methane releases was very exciting to the environmental community. And thirdly, higher civil penalties for repeat offenses and where there are multiple instances of the same violation. Each factor, and right now, statutorily and in the regulations, there are 5 factors and 2 optional factors that we look at in determining civil penalties. Each factor builds upon the other, so it's difficult to quantify exactly or precisely how much civil penalties will increase as a result of these recent measures. However, I mean, it could double, could triple, just depends upon what factors are applied and how they build upon one another. So the purpose, as we stated in the Federal Register notice, is to increase deterrence against noncompliance and further drive down the risks of incidents. At the same time, and in the same Federal Register notice of October 17th, we announced greater transparency for penalty determinations. So it used to be that before an enforcement proceeding, an operator could request a copy of our civil penalty summary. And this was a generic summary sheet, some of you may be familiar with it, that kind of explains the ranges of penalties for each of the statutory factors. And now, after this Federal Register notice, we are now posting that civil penalty summary on our website. It was also attached to the Federal Register notice. In addition to that, PHMSA is now making available to operators in enforcement proceedings the penalty calculation that the agency relied upon to reach the penalty determination. And that penalty determination will be provided to operators upon request. So that concludes the higher civil penalties and transparency portion of our Food for Thought. Now let's take a look at PHMSA's rigorous case management and how that might encourage compliance and enhance deterrence. So first of all, PHMSA has accurate and complete enforcement data. We track cases every step of the way. And the data that we have is posted in a very transparent way on our website. So we have a enforcement transparency website, and all case-related information is posted there. And interestingly, PHMSA's collection rate is close to 100%, and that is also highlighted on our website. So in our view, by posting this information on the website, it can deter future violations because it shows, first of all, PHMSA's very strong commitment to enforcement and to seeing it through, and it also gives visibility to the entire industry of what is going on with PHMSA's enforcement, in PHMSA's enforcement arena. So we post everything from the notice letter, the operator's responses, the final order, any petitions for reconsideration, all of the related briefs, and we also post all payments on our website. Our efforts have paid off. Because of rigorous case management, arguably, we've been able to cut in half the case processing time. So whereas if you take a look at this chart goes from 2009 to 2015. And you'll see that, as the curve indicates, case processing time from the time that a notice letter is issued to the time that the case has closed has been cut by 50%. So positive results that could flow from this fact is that it shortens the time unsafe conditions are allowed to persist, it shows PHMSA's enforcement resolve, and it enables timely analysis of enforcement data. And as part of PHMSA 2021, that is becoming increasingly important to our agency. So we've talked about PHMSA's new emergency order authority. We've talked about PHMSA's efforts to enhance civil penalties and to improve transparency. And we've talked about PHMSA's rigorous case management and the benefits that have resulted from that. And these are all on the civil side. I don't have a slide on this, but I just wanted to speak for one moment about what PHMSA is doing on the criminal side. So you may be aware that PHMSA routinely cooperates with DOJ, U.S. attorneys' offices from around the country on criminal matters. And basically there, what has to be found is that an operator's conduct or a violation was willful and knowing. And I guess that one of the most recent versions of that, and it's just one, is the PG&E litigation in California. Northern District of California, U.S. Attorney's Office reached out to our office, and our agency provided a lot of expertise. In fact, one of our folks, Steve Nanny, was actually named as an expert in the proceeding in Northern California. And we assisted them every step along the way. Now, in that case, CPUC, the California Public Utilities Commission, basically had the lead, but PHMSA was assisting in terms of the federal minimum standards. And we cooperated throughout that proceeding. And what ended up happening, and this particular proceeding, PG&E, was out of the San Bruno accident that resulted in a lot of destruction of property and many fatalities. And PG&E was found guilty of willfully and knowingly violating PHMSA's integrity management regulations at the end of the day, and they will be sentenced in November. So that is one way in which PHMSA is cooperating in criminal proceedings as well, and we have other similar cooperations going on at the present moment with U.S. attorneys' offices throughout the country. So both civilly and criminally, we're taking steps to improve and to enhance our enforcement efforts. So I wanted to just thank you so much for having me here today. It's been a real honor and a privilege to be here at the conference. I've thoroughly enjoyed it, and I'm just very excited about the common denominator that we all share, which is our passion for pipeline safety. So thank you very much.